Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2 of Jefferson County, Texas. My name is Judge Terrence L. Holmes. I'm the judge presiding here in County Court at Law Number 2. This morning, you were asked to come here for what is called an arraignment. And what the arraignment is an opportunity for the court to tell you what you have been charged with, what your rights are, and what options that you have regarding your case. The case that you have in this court is classified as a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. The felony cases are your most serious type offenses, and your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they are not serious. For a felony case, those cases are held in the district court. We call those the felony courts. It's the district court. They handle capital murders, first-degree felonies, second-degree felonies, third-degree felonies, and state jail felonies. For capital murder, the range of punishment, if you're convicted, is life or death. For a first-degree felony, the range of punishment is 5 to 99 years in the state penitentiary, fine up to $10,000. For a second-degree felony, the range of punishment is 2 to 20 years in state penitentiary, a fine up to $10,000. For a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, a fine up to $10,000. And for a state jail felony, the range of punishment is from 6 months to 2 years in the state jail, fine up to $10,000. Now, for a misdemeanor offense, the range of punishment does not include punishment in the state penitentiary. In essence, you cannot be punished and sent to the state penitentiary for your misdemeanor. Now, for a misdemeanor case, they're divided into Class A, Class B, and Class C misdemeanors. Your Class C misdemeanors are fine only. That's the range of punishment. And those cases are normally held in the Justice of the Peace Court, we call it the JP Court, or the city court, which is the municipal court. And as I said, it's fine only. However, if any one of those cases are appealed, then it will come up to this court, the county court at law. And the range of punishment is still the same, which means that you only can get a fine, you cannot be given jail time. Now, for the other misdemeanor cases that we handle in this court, the Class A and the Class B misdemeanor, the Class A misdemeanor is the highest misdemeanor that you can get. The range of punishment for a Class A misdemeanor is a fine from $0 to $4,000 or anywhere in between, jail time from 0 days to 1 year, which is 365 days, or anywhere in between, and the jail time is in the county jail. Or you could be given both such fine and confinement. Now, for a Class B misdemeanor, the range of punishment is a fine from $0 to $2,000 or anywhere in between. Time in the county jail from 0 days to 180 days, which is 6 months or anywhere in between. Or you could be given both such fine and confinement. So said that to say this, the case that you have in this court is either Class A or Class B misdemeanor, or if it was appealed up, it could be a Class C misdemeanor. As a defendant in a criminal case, you have rights, and that paperwork that has been handed out says that as a defendant in a criminal case, you have 3 options. And the first option is you may hire an attorney. The second option, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you've already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is I want to apply for court-appointed counsel, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your signature on the line that says defendant, and you will put today's date, October 26th of 2021. Now, for those of you who will be waiving your right to an attorney and representing yourself, you will have to read and sign the second page, which is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 26th day of October 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that's your choice, you will sign on the line that says defendant, and you will date it today's date, October 26th of 2021. Now, also as a defendant, you have other rights. You have a right to have a trial by jury. In that area over there where those 12 chairs are, we call that the jury box. Actually, 6 citizens from Jefferson County will be selected on your case if you choose to have a jury trial. And they will decide whether or not you're guilty or innocent after listening to all of the evidence. You also have a right to waive or give up your right to have a trial by jury. And that simply means that you will not be having a trial by jury. And if you do so, your case will come before the judge. And your case will come before the judge in one of 2 ways. It can come before the judge by a trial, or it could come before the judge by a plea. And when I say a plea, is if you plead guilty or no contest, then your case will come before the judge. Now, if it comes before the judge by trial, we call that a bench trial because it's a trial without a jury. It's a trial before the judge. The judge will decide the facts and decide whether or not you're guilty or innocent after listening to all of the evidence. Now, if you come before the judge by way of a plea, there are 1 or 2 pleas that you can come before the judge with. One type is called an agreed plea bargain or an agreed plea. And the other one is called an unagreed plea. The difference between the two, an agreed plea is when you and the state, the district attorney's office, have reached an agreement on your case, and you come before the judge with that agreement. We call that an agreed plea. Now, if you in the state or the district attorney has not reached an agreement to settle your case, and you still want your case to come before the court by way of a plea, we call that an unagreed plea. At that point, you and the state have not agreed on a plea, and you want the judge to decide what the punishment in your case will be. Now, you also have a right to have witnesses to come to court in your case. And witnesses, they can testify either for you or against you. You also have a right to ask them questions. If you have a lawyer, your lawyer will be asking them questions. If you're representing yourself, you'll be asking them questions. And we call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. And if you do so, you will not be calling any witnesses. However, the state will be calling witnesses in the case. Now, you also have a right against self-incrimination. And what that means, you may have heard from time to time, either on television or in public, you heard people say, I'll take the fifth. And what that means is that you have a Fifth Amendment right against self-incrimination, and you have a right not to testify in your case if you do not wish to do so. However, you can waive or give up that right and testify in your case if you decide to do so. You also have a right to have discovery. And what discovery is, you have a right to see or discover or to see the state's evidence that they have against you. You have a right to have access to the reports, videos, documents, whatever evidence that they have against you, you have a right to have access to that. Or if you're represented by your attorney will have access to the discovery or have access to the evidence that they have against you. Now, everyone here who, well, let me explain something to you. I mentioned earlier that you could either enter a plea of guilty or no contest. Now, actually, you could enter one of three pleas. You can enter a plea of not guilty. And if you enter a plea of not guilty, you're saying you didn't commit the offense that you've been charged with. Or you could enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting those charges. Now, everyone here, you are out on bond. And that's simply because you was arrested and placed in jail, and then you were bonded out. Every day that you spent in jail, it can be used as credit towards your punishment. For example, let's say you and the state have negotiated and y'all reached an agreement that they're going to agree to give you 5 days in jail. You've already spent 5 days in jail. If that's the case, you'll not have to spend any more time in jail because you'll be given credit for time served. If, however, they are offering more than the 5 days, then whatever time that is in excess of the 5 days, that's the amount of time that you will have to spend. So for example, if they offer 7 days, you have served 5 days, that means you would have 2 days to do because you subtract the 5 from the 7. Now, if they're offering you a fine, every day that you spent in jail, that is credited as $100 per day that will go towards your fine and court costs. So if they are offering you a fine and court costs of $500, you spent 5 days in jail, that's $500. You wouldn't have to pay anything, and the fine and court costs will be taxed and retired. However, if they are offering you a fine and court costs in excess of the $500, for example, if they are offering fine and court costs of $700 and you spent 5 days in jail, you have credit for $500. And so that simply means that you will owe $200. And if you cannot pay the $200 on that day, then there's something that we can do. We can put you on what is called a payment plan. In essence, we can give you payments. You can make payments in installments to pay off the remaining balance. Let's say you cannot pay the balance at all because you do not have the income. And so therefore, that's not a problem either because Section 42.15 Texas Code of Criminal Procedure allows the court to convert your fine and court costs to community service. So that just simply means that you'll work off the fine and court costs. Now, every hour that you do in community service, $12.50 will go toward your fine and court costs. So if, for example, if you work 8 hours of community service in one day, that's $100 that will go toward your fine and court costs. Now, also, if you in the state have reached a plea bargain agreement, the court, that is the judge, does not have to follow that plea bargain agreement. If the court does not follow that plea bargain agreement, then you'll be entitled to withdraw, which means you'll be entitled to take your plea back. In essence, you've entered a plea of guilty, no contest, and you come before the court and the court says, well, okay, they're giving you $500 fine and court costs. I'm not going to follow it. Then you can say, well, judge, I take my plea back. I don't want to plea. You can do that. Now, if the court does follow the plea bargain agreement that you have reached with the state, within 30 days, and you decide that you would like to appeal your case, when an appeal is you would like a higher court to look at your case to see if you've been wrongfully convicted or we committed an error by convicting you, and you have to get permission to appeal your case. If the court follows the plea bargain, you have to get permission from that judge to appeal your case. Now, if the judge gives you permission to appeal your case, then your case will go up to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case. They will decide whether or not you've been. Now, they can decide one or two things. They can grant your appeal or they can deny your appeal. If they grant your appeal, then they'll decide whether or not you've been wrongfully convicted or whether or not an error has been committed. Now, if they deny your appeal, then at that point, you can appeal your case to a higher court than them. That higher court is called the Texas Court of Criminal Appeals. It's located in Austin, Texas. It is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. And I'll explain that to you. Pro se means you are doing it on your own without an attorney. And you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not an error was committed by convicting you. If they grant, they can do one or two things. They could either grant or deny your pro se petition. And as I said, if they grant it, they can decide whether or not, if they grant it, they can simply find you not guilty, or they can send the case back down to this court and ask this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, at that point, your conviction will stand. Now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. And with the pretrial diversion program, it's a program for first-time offenders. And basically what happens is this. You're placed into the program, your case is dismissed. If you complete the program, then you can get this case, this criminal case, expunged from your record. Expunged meaning it could be erased, deleted, or wiped off of your criminal history. Now, in order to get into the program, the offense cannot be a unlawful carrying a weapon or resisting arrest. You have to have an attorney to assist you to get into the program, and it has to be, as I said earlier, your first offense. You can't have a criminal history. If you are a veteran of any one of the branches of the United States military, the District Attorney's Office has a program that is called Veterans Court. That program is for veterans only. If you'll get, if you are accepted into the program, then the case will be, once you complete the program, the case will be dismissed and you can get it expunged from your record, just like the pretrial, it's part of the pretrial diversion program. Now, this court, which is County Court at Law Number 2, has a program that is called the Csi Program. That the Csi Program was a program that I started within the first 100 days of my being in office. So I started the program in March of 2017. So I started the program over 4.5 years ago. And that program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so the way we address that program, the way we address that issue is through various partnerships that we have with agencies in our local community. We have a partnership with Spindletop Center. It used to be called Spindletop MHR. And MH and MR. That program that we have with Spindletop, we have a mental health officer and we have counselors who are here in the courtroom, and they can do a private interview. Spindletop can also do an assessment. They can do it and develop a treatment plan for you, either outpatient or inpatient. They also have a program that is called the Atar Program. Atar stands for Addiction Treatment and Recovery. And with that program, if individuals have problems with drugs or alcohol, then they can get a private screening. They can have individuals to do an interview with them. They can also have a treatment plan developed, either outpatient or inpatient, depending on what is shown in the screening. And those programs are run through the Spindletop Center. Spindletop, and they also have what we call OZAR, which is our local drug and alcohol recovery program, that they can do screenings as well. And they can develop treatment plans for you and for inpatient or outpatient services. If you are unemployed, or if you have you would like to have a career change or get into a career, we have a partnership with Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is referred to as CICE, and it stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of those areas, they will assist you at getting placed on a job in the area that you are trained in. If you do not have your high school diploma, they have a GED program where you can get your high school equivalency diploma. All of those programs that I have just mentioned to you is part of our CSI program, and all of those programs are free. It does not cost you anything. Only thing you have to do is have a desire to be in any one, or you could be in more than one of the programs if you desire to. And all of those programs that I just mentioned can be used as community service. So for example, if you cannot pay, if you in the program, you can say you cannot pay your fine and court costs, we'll allow you to do community service. You have mental health issues, we put you in the Spindletop program. While you're in that program, every hour of counseling that you get, $12.50 will go toward your fine and court costs, and 1 hour will go toward your community service. Or if you're in the drug and alcohol program, 1 hour will go toward community service, $12.50 will go toward your fine and court costs. Or if you're in the job training program, while you're in class being trained for a job, 1 hour is going toward community service, $12.50 is going toward your fine and court costs. So in essence, you're killing 3 birds with 1 stone. In essence, you're in the program, you're getting community service, and you're paying your fine and court costs. You're doing one thing, but you're actually doing 3 things at one time. And so all of those programs I said are free. And all those programs were started here in County Court at Law number 2. And I tell people this all the time. When you come to County Court at Law number 2, we don't have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference in the community in which we live, which is Jefferson County, by producing productive people. And we believe that if you produce productive people would not commit crime, and therefore we make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And so that, as we say with those programs, all of those programs are free. If you're interested in any one of those programs, just let us know, and then we'll be happy to accommodate your needs. Now, as I said earlier, we do not just arrest the problem, we address the problem. And we believe by addressing the problem, we can address the issue of recidivism. Now, we have someone here, Deputy Hinton, who is he's our mental health officer. He's from the Spindletop Center, and Deputy Hinton is going to come before you and tell you something about the program that they have at Spindletop. Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve. I'm here with a couple of my partners. Spindletop, where we out here today. Qualified mental health professionals. The reason we are here in the courtroom is because the judge has graciously allowed us in his courtroom because he cares about every person who comes before his court. What the judge has discovered and determined that whether this is your first time or your 10th time here, there's sometimes underlying issues that have brought you here today. Those underlying issues could be mental health or substance use disorders. We believe if you can address those issues, if you will, then we can get you out of the cycle of arrest. But it's going to take one thing, and that's going to be for y'all to reach out and get that help. We'll be here. We'll also be able to speak to you privately. All your information is private, HIPAA regulated, so no one is going to know about our conversations or any services that you may get into, but there are services for everyone. Should this apply to you? Maybe it doesn't apply to you. Maybe it applies to someone in your family that could use this information. We will be glad to talk to you about that and get you the resources and information you need to help them and carry that back to them as well. Does anyone have any questions? Yes, ma'am.
Well, this is gonna be my first time appearance, and I would like to get more information about that because I want the counseling for me and my kids.
Very good, very good. And that's exactly what we'll do. So as soon as we close here and the judge goes in recess, I'm going to be visiting with everyone here, and we can talk a little bit more in depth about your situation or whatever fits your particular situation that you need. Okay, thank you,
Okay,
Your Honor.
all right. Thank you, Deputy Hinton. Now, ladies and gentlemen, the paperwork that you have filled out, the court staff is going to pick that paperwork up from you. That's going to take a little time for us to do that, and we're going to go through it. We're going to put you into various different categories, and so just be a little patient with us. So at this time, ladies and gentlemen, we'll be in recess to give our staff time to do that.